So we're going to jump back into Richard Morgan Casey's testimony to the Post Office Horizon IT inquiry, where despite previously denying that he was aware of the Post Office's motivations and subsequently has been shown in attendance notes that at least Mandy Talbot and the Post Office were suggesting that the money recovered from Lee Castleton personally was less important than being able to set a precedent viewed as a kind of test case. He nevertheless advises, following Lee Castleton's judgment, on how the Post Office can derive a maximum advantage and value for money from the exorbitant amounts they've spent pursuing Lee Castleton by setting a Castleton precedent that they could use in future cases to make them much easier and much less costly to win against sub-postmasters. Let's jump into the inquiry.
Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
So can I start by picking up on a document that may assist both you and Mr. Morgan to answer the questions that you asked him before we took the break, and asked to be displayed poll 308 1826. I can't ask for that to be displayed. Essentially, sir, I'll come back to this in the hope that in the next half an hour that document is onto the system, but it is the rest of the Tomlin order obtained from a different source. It's amongst documents that the inquiry has recently been provided with, which is why it's not on the display system at the moment. Whilst that's done behind the scenes.
Is paragraph 5 in the same terms as the...
Yes and no. So let's look at the document when I can display it. Thank you. You've told us that before you argued the case at trial,
Yes.
You didn't think that this was a test case at all, and it was essentially a case that turned on its own facts.
Yes.
Can we look, please, at poll 307 0020? This is an attendance note of the 22nd of January 2007, and you'll see that it is described as hearing of judgment poll against Post Office Limited against Lee Castleton, an attendance note of Mr. Dilly, and then scroll down a little bit, please. Hearing of judgment Post Office against Lee Castleton. It sets out who's present, and then there's some arguments about costs.
Yes.
Then over the page, please, more arguments about costs, and then scroll down to the penultimate paragraph. Thereafter, returning to Council's chambers and having joint telephone conference with Mandy Talbot to update her on the outcome of the cost submission, she was very pleased. Richard also offering to supply her with a separate note on how she could use the judgment, and advising that under the new procedure, the sub-postmasters don't physically sign off the accounts that they supply every month. She should think about getting them to do this.
Because if they did, then this would, even if it's not a test case, act like a bit of a test case to say, well, we've proven this before, you can refer to the judgment of this order in the case of Lee Castleton.
She explained that is what the legal affairs team in the Post Office has advised them to do when they changed the system, but they were overridden by business concerns, RM suggesting that they at least electronically sign some certification on the accounts, stating that they accept that they are true and accurate and representing a fair position on profit and loss, stock and cash, because if this case ever arose again, then it would make it much easier for the Post Office to rely on the Castleton precedent and get judgment against sub-postmasters and not incur such great costs next time. Was this an offer by you to help the Post Office get maximum value out of this precedent?
Again, it's a very long time after the event, but it's no more than an impression of a recollection, is that after the judgment was given, we had a discussion about whether it was any use. And you sort of see it picked up there. There was some exchange where she told me, or somebody told me, that the Post Office's whole system had changed and that they were no longer going to have cash accounts, or no longer going to have daily cash accounts and weekly accounts and so on and so forth. And my response was that that meant that Castleton was not going to be of any use unless they had the cash accounts that we'd relied on at trial to achieve the same accounting position. And that was the note that in due course I produced. I think that's somewhere in the bundles.
Can we look at that, please? It's WBON 5023.
So, test case or not, they were looking to use it to set a precedent, shall we say, that they could use in future. That much is clear, whatever they want to call it.
If we just scroll to the last page, please. One page up, sorry. That's the back sheet. And then scroll down. We can see that it's an undated advice written by you. You've helpfully told us in your witness statement by explaining that the Chamber's fee system shows that it was sent out on the 22nd of January 2007.
Yes.
So if you go back to the first page, please. You say, following judgment, I've been asked to provide a short written advice on the key points that have emerged from my involvement in the case as a whole and the judgment in particular. I should emphasise the advice has been written as a short preliminary overview and should not be relied upon as providing a final and definitive consideration of all steps that should be taken in order to ensure that the Post Office derives maximum advantage from the judgment. And just stopping there, did you know beforehand that the Post Office wished to derive maximum advantage of the judgment, i.e. before judgment had been handed down?
No, but there again, I didn't even know that we'd won.
I'm sorry?
There again, I didn't even know that we'd won before the judgment was handed down.
No, but were they not telling you that they regarded this as a case that it was an important precedent or could be seen as a test case?
Not that
and that it was a case in which the Post Office wished to use to deter other postmasters from bringing claims?
Having seen the email that you took me to before the break, I can see that that was one of their objectives. But it wasn't the basis upon which the claim was run. Having won the case, this advice is given in order to provide a steer as to how it might be relied on if the same procedure is followed in the future.
So we can accept his point then that he didn't change the way he was going to run his case, whether the Post Office wanted to use this as some kind of test case or precedent-setting case. But nevertheless, he's, I think, admitting now that actually that was a stated view of the Post Office during the case, before the case, and now after the case when he's helping them derive maximum judgment from it.
Reading on paragraph 2, please. You say the first point is that it is easier to sue a sub-postmaster on an account produced by him than trying to prove that a loss has arisen in the business. Trying to prove such a loss, if it is possible at all, is extremely difficult forensically and will inevitably be expensive and time-consuming. The second point is that the Post Office derives a significant advantage in litigation if the sub-postmaster bears the burden of proof to show that the account sued on by the Post Office, such as the cash account final, is wrong, rather than the Post Office having to prove that the account sued on is right. This reversal of the burden of proof can only occur if the Post Office is suing on the sub-postmaster's own account, i.e. on a formal account produced by the sued on by the Post Office, such as the cash account final is wrong, rather than the Post Office having to prove the account is right. The reversal of the burden of proof can only occur if the Post Office is suing on the sub-postmaster's own account, i.e. on a formal account produced by the sub-postmaster and tendered by him to the Post Office as his confirmed statement of the trading that has occurred. Then over the page. As such, a cash account final or any other account produced by the sub-postmaster is only likely to be treated as a final account for a given period if it is 1, produced by the sub-postmaster, 2, at least in circumstances where he's contractually required to produce and verify the figures as accurate, but preferably where he formally certifies the figures as such, and 3, where the sub-postmaster physically signs off the accounts as such, alternatively signs electronically. Third and final point is that if and when it's decided that a sub-postmaster is to be suspended or removed from post, he should be required, in accordance with the terms of his contract, to produce and sign a final account of the date of his removal, whether or not the Post Office has conducted its own audit. The purpose of requiring this is simply to rely on the reversal of burden of proof and remove the necessity, though not the desirability, of having to call the auditors to prove the loss.
Essentially, we can shift the work onto the sub-postmasters that are accused rather than having to do the work ourselves, is what it sounds like.
You say here that sub-postmasters should be required to sign the cash accounts. Was that language reflective, as you understood it, of the Post Office's attitude, as you had come to understand it, that they were happy to impose conditions on a postmaster that may have the effect of, for example here, reversing the burden of proof and thereby obtain a dominant position or a position of power over the sub-postmasters?
No. This is almost a sort of reflection of my chancery background. It's more that the principal-agent relationship entitles the principal to rely on the account stated by his agent as being final and definitive. And in order to show that the account is that of the agent, it would be rather sensible to have it signed by the agent. So this note is written as a chancery practitioner giving advice as to the formal situation in which an account stated arises as between an agent and a principal, not a reflection of the position as between a sub-postmaster and the post office, although as reflected in the terms of the contract as then in existence between the post office and sub-postmasters that had been relied on in the Castleton case, that seemed to arise as a matter of necessary implication from what I can remember of the contract, but I haven't reread the contract in the last 17, 18 years.
In relation to this advice, was it based on the assumption that the loss of which the Post Office complained was a genuine one?
Yes.
And not an artefact of the computer system?
Yes.
But in the advice, it does talk about it shifting the Post Office away from having to prove that a loss has occurred.
Again, as somebody practicing my field, I can't conceive of people signing off on documents that aren't true.
Well, if only, we might be in a much better place as far as the Post Office scandal is concerned, especially judging by what we've heard from some witnesses about documents that they've signed.
What about somebody signing off on documents because they have to continue to do so to trade into the following week, and they phone a helpline dozens and dozens of times and say, these things I'm signing off, they're not correct?
Yes, I mean, that's something that seems to have emerged subsequently in the Post Office, in the case in front of Mr. Justice Fraser. I mean, I haven't followed that in any great detail, but I can quite understand why people might say that it's signed under duress and so on and so forth. When this matter came back to me on the Rule 9 request, one of the things I did was go back and look and see whether Mr. Castleton had himself given any indication that the figures he'd signed off were inaccurate, or that he'd signed off on them because he was under some duress or there was some other reason. And I didn't at the time, and I still don't get any hint of that in the pleadings or the evidence. But, I mean, there are all sorts of reasons why figures might be wrong or so on and so forth. But at no stage during the trial, so far as I can recall, did Mr. Castleton say that his figures were wrong. Had he done so, the consequence would have been that the trial would have been adjourned, the matter would have been remitted to a master for an account to be taken, and we would have gone through the same process and established what the actual loss was by reference to amounts by way of cash and goods within the business, what had been taken out, what had been paid in, what had been transferred out, what had been transferred in. There had been a process of verification of the account on the old account stated procedure.
Well, if we go back to his opening statement where he says, I'd like to open the case on behalf of Lee Castleton to help him out, maybe he could have helped him out with that suggestion at the time to say, did you actually, the documents were accurate? If not, we can do this full process to establish if there are any discrepancies. That certainly sounded like that would have been helpful to share.
So we would have got to an answer. It might not have been the same answer, but the whole process of the amended particulars of claim was to establish what the actual real loss was.